All rise. The Minnesota Workers' Compensation Court of Appeals is now in session. The Honorable Deborah K. Sundquist presiding.
Please be seated. Good morning. We're here today on the Ludwig versus Dakota County case. That is file number WC 246562. I am Judge Sundquist. I'm joined today by Judge Sean Quinn on my left and Judge Tom Christensen on my right. We are being live streamed today, so I ask that you speak up. We do have some issues with our technology this morning, so we're not sure how this will go out, but we understand that the feed to the Zoom will work. As you know, you each have 15 minutes to present your argument this morning. The first 3 minutes of your argument will go uninterrupted by questions by the judges, but after that, we have several questions we would like to ask both parties. Mr. Schwab, you're here on behalf of the appellant, the employee, correct? And Mr. Locke, you're here on behalf of the employer and insurer? Self-insured employer. And who are you being joined with by today? And Ms. Johnson, what is your role? Okay, so that means what? All right. Typically, we don't have second chairs at our oral arguments. I think it might give a disadvantage to the appellant who doesn't have a second chair. So I'm going to ask you to step back into the gallery and have Mr. Locke present his argument. Thank you. Counsel, when you're ready.
Your Honors, opposing counsel, may it please the court. My name is Eric Schwab and I represent the injured worker in this matter, Ms. Cindy Ludwig. We are here today to ask the court to reverse the determination by the workers' compensation judge relative to primary liability for the September 8th, 2021 work-related injury. Additionally, we're asking the court for a remand in order for the compensation judge to determine if permanent total disability benefits should apply, as well as liability for the May 7th, 2022 consequential injury. We have multiple dates of injury in this case, so just to be clear on what we're asking for, the September 8th, 2021 injury we'd like the reversal on. The October 29th, 2021 injury, which was mentioned in the briefing, is not being appealed, so we don't need to address that here today. And then the May 7th, 2022, we're asking for a remand so the judge can make additional findings once we establish primary liability for the September 8th, 2021 injury. We're asking for a reversal for two separate reasons. First is that the compensation judge erred in determining that Ms. Ludwig was not completing a special errand at the time of her injury. Second, the compensation judge erred in determining that Ms. Ludwig was not injured by a special hazard. I'd like to focus first on the special errand. I believe that is the stronger argument. Additionally, I believe the legal analysis is a bit more clear for the special errand. In order to be on a special errand, Ms. Ludwig needs to meet the three criteria in the Youngberg analysis. The three criteria are an explicit or implicit request to complete work outside of normal work hours. Two, that the trip is an integral part to the service being provided. And three, that the task is not a regular or reoccurring task. Ms. Ludwig clearly meets all of these requirements. On the first standard, Ms. Ludwig was explicitly told on a conference call by multiple supervisors prior to September 8th, 2021, that she needed to return to work and set up her work equipment prior to the start of her shift. This was an explicit request by her employer to complete an activity to be ready to complete her normal work activities at 8 a.m. She therefore had to complete this task outside of normal working hours. Second, the trip was an integral part of the service. Ms. Ludwig was being asked to transport work equipment from home to the office for the purpose of setting up her workstation. She cannot set up her workstation with her work equipment without first bringing her work equipment to the office. Finally, the task is not a regular or reoccurring task.
Mr. Schwab, your 3 minutes are up. Judges, any questions?
I do. So, Mr. Schwab, your outline of the criteria, that's accurate, and I understand where you're going with this. But in order for us to even attack these criteria, the injury must have occurred during this special errand or special task. Finding 13, the compensation judge did not find the history provided by the employee as to how September 8 happened reliable. If she doesn't believe your client's story of what happened, then what are the, and that wasn't appealed, what are the facts that say she got hurt during this event?
So the judge in her decision pointed out when she felt things were reliable or things were credible. She did a pretty decent job of doing that. And she pointed out that how she was injured was not reliable. She did not say when she was injured was not considered reliable. In an additional finding, the judge actually did point out that Ms. Ludwig had intended to and did leave at 7:15, which was earlier than her normal time of 7:30. And the judge didn't question the employee's credibility on that. She questioned the mechanism of the fall and exactly, the circumstances around the fall itself. But the judge made no kind of credibility determination necessarily on the time of the injury. And Ms. Ludwig was injured having left the portal of her house, putting the work equipment into her vehicle. So she was in the process of completing the special errand at the time of her injury.
Yeah, I do have a question about that coming and going. So does the special errand exception apply here at a time before she actually gets into her vehicle?
Yep, according to, I think it's Bengston. I'm terrible at pronouncing names, so I apologize if I mispronounce that one. But on a special errand, my client would be afforded portal-to-portal coverage. At the time of her injury, she had left the portal of her front door and was loading the work equipment into her vehicle.
But she hadn't finished that task. She still had the chair to bring in, correct? So how is that leaving?
She did, but she had left the portal of the front door. In the Bengston case, what had happened there is kind of similarly, but on the back end, the employee was returning from a special errand and was in her own driveway right outside of her front door and fell. I mean, we're talking about a very close proximity, but my client had started the special errand at the time she was injured. Now, the compensation judge in this matter made an additional error because she essentially analyzed this case using the recently decided Thompson decision. However, the proposition the judge kind of took away from the Thompson decision was that bringing work equipment was not within the course and scope of employment. And if you read the decision, that's what kind of comes out, is that the judge essentially says, in that case, returning work equipment wasn't compensable. In this case, it's not. I think that analysis is in error. Specifically, this case is very distinguishable from Thompson because in Thompson, there was more of an implicit request for Thompson to return the work equipment. There didn't appear to be a requirement to necessarily set up the work environment. In this case here, we have an explicit request in unrebutted testimony by Ms. Ludwig that her supervisors instructed her to return the equipment and set it up. And the ambiguity of that determination in Thompson is what allowed this court to defer to the compensation judge. We don't have that ambiguity here. We have an employee being told specifically what to do, when to do it, and she was injured while completing that task. Now, in addition to the special errand, we also have the special hazard. However, I would just like to point out that for a special errand, there doesn't need to be any additional special hazard or anything like that involved. So this is an additional analysis should you find that she was not on a special errand.
I have a question, as long as we're still on the special errand before you go into the special hazard. Uh, In the special errand elements, is there an element or is there any sort of nuanced requirement that the act of loading the vehicle caused the fall? Do we need to actually establish a causal link between what she was doing and the injury in order for the special errand exception to apply?
I don't believe you need to. Special errand and traveling employees have kind of similar requirements once portal-to-portal coverage kicks in. You're not really looking for necessarily what caused the injury, rather that it occurred during the portal-to-portal coverage period. The case law has been pretty clear about that. I can't think of a case that would be contrary to that opinion.
And how would that influence the decision in this case?
If you find that Ms. Ludwig is on a special errand, then there doesn't need to be additional analysis on if the work equipment itself actually caused her injury or not. She's then entitled to portal coverage. She was injured during that portal-to-portal time period, and then the injury should be compensable, and I believe the analysis would end there.
Thank you.
I have a question. In terms of, in looking at the memorandum, not in any of the particular findings, the decision seems to discuss this injury occurred on just a normal commute. She was bringing the equivalent of material, which we all do. Can you address that for me? Why this is just not a commuting injury and the statute doesn't apply?
Certainly. So this is very different than a normal commute, because if we look at Ms. Ludwig's work history, she was hired by Dakota County in 2002. And for the first almost 2 decades of her employment, she's not bringing any work equipment home. Nothing's really changed. We have a normal commute happening there. We don't have this issue with the work equipment. Once COVID hit, once in a lifetime pandemic, she's sent home and has a new work environment at home. And she stays there until she's specifically requested to bring back work equipment and set up her environment. What I think really distinguishes this from a normal type of commute is that she was instructed to not just come back, which would be arguably a commute. She was supposed to set up and be ready to work by 8 a.m. So the act of setting it up brings certain risks that a commute simply doesn't. If you think about the act of setting up a computer on a desk, you're now asking an employee to lift objects, bend, twist, use fine manipulation. You're asking them to do things outside of their normal commute. So the special errand comes in because the employer's now asking for additional labor, things outside of the normal work. And when the employee is injured during that time, it should be compensable.
And speaking because of COVID, and as I understand the fact, she was coming back. This is her first trip back after a COVID break from working at home. Was her work station at home then a premises, and she was going from a premises to one work premises to another work premises? Can you address that?
Sure. She certainly could have been going from one premise to another. After she returned, she was going to be working then a hybrid schedule, but her normal type of going back and forth between the work premises wouldn't require the same setup that it did on October 8th, 2021. Now, I have a couple minutes left. If I have questions, I'm happy to answer them, but I would like to reserve it if I could.
Actually, Mr. Schwab, I would like you to just briefly address the special hazard exception.
Certainly.
Argument that you made.
So a special hazard exists if the employee is exposed to a hazard that originates on the employer's premises and either is part of the work environment or exposes the employee to an external hazard. In this case, the hazard, as described, are the monitors, chair, various work equipment that Ms. Ludwig was required to bring back as part of the requirement to set up her workstation. When she was injured, she was putting the equipment into her vehicle. Now, the compensation judge was a little bit skeptical on exactly what the mechanism of fall was, but from a practical standpoint and looking at the transcript, we can see that really the only reasonable explanation that we can come up with is that either Ms. Ludwig was pushing the work equipment which caused the fall, or was at a minimum in an awkward lowered position at the time of the fall because of the work equipment. So it's her interaction with the special hazard that caused that injury.
So in that case, I'm
Go
sorry.
ahead. Go ahead.
So in that case, you would have to have, there's an implied requirement that there be some connection to her work as opposed to special errand where there doesn't necessarily have to be.
Correct.
Okay.
Yes.
One completely off the wall question relative to everything else you've argued. In your notice of appeal, you appealed issues 1 through 11. It's not mentioned anywhere in your brief. Is there a reason why those are appealed? The actual outline of the issues?
I would have to take a look, but I would say my brief stands on its own.
Okay.
Okay.
Fair enough. Fair enough.
All right.
I don't think there are any more questions. So if you would like to reserve the last 1.5 minutes,
I would. Thank you.
thank you. Mr. Locke, when you're ready.
May it please the court. I am William G. Locke. I represent Dakota County, Self-Insured. Here, as we've heard, the appellant is trying to convince this court that the record shows the employer directed or required her to do something above and beyond her usual scope of her job, which is just not the case here. The record as a whole, including the appellant's own testimony, does not show that there was any express or implied request or any direct order from the employer to transport equipment. When the appellant was asked who told her to return to work on September 8th of 2021, she testified that she had a conference call with manager Dawn Klein and the manager of her department, Scott Lyons. When asked if she was supposed to return at a specific time, the appellant testified that work times were from 8 to 4:30, and it was required to me to be at work before 8 o'clock so I could set things up. This is the only information in the record regarding any direction from the employer about returning to work in the office. Now, appellant concedes in her brief that had she simply been transporting a laptop that day, she would not have been completing a special errand, since transportation of the laptop between home and office was regular and reoccurring. She then contends that the task of coming into the office to set up her workstation existed only on September 8th. The record and the findings support that this is not a one-time occurrence. At finding 7, Judge Surges stated the employer allowed appellant to bring her laptop and related equipment back and forth from home and the office. Appellant even chose to purchase monitors for her home to avoid having to, in her words, bus the monitors back and forth. Now, she concedes that an analysis under Youngberg is not mandatory, but insists that the application of Thompson was legally flawed because her case is distinguishable from the facts in Thompson. Thompson, we know, is a 2004 case recently decided by this court. Youngberg is a 1963 case involving the employee's car accident on the way home from a company bowling event. Now, if we look at the elements in Youngberg, number 1, was there an implied or expressed request that a service be performed outside of usual work hours? No. The record only shows that the employer informed appellant of her hybrid work schedule, including working in the office Wednesday, Thursday, and Friday. And that appellant's shift on Wednesday, September 8th, 2021 was at the usual time from 8 to 4 o'clock. The record does not show that the employer explicitly or implicitly provided direction regarding what, if any, items were to be brought to the office, when the items allegedly needed to arrive at the office, or whether appellant herself had to be the person that transported the items. Element 2, was the trip involved on the errand an integral part of the service performed? Again, no. The trip appellant intended to make on September 8, 2021 was her typical commute to work with no deviation. It was a normally scheduled workday for the purpose of arriving for her normally scheduled 8 a.m. shift.
Mr. Locke, I'm going to stop you there because we're a little bit past the 3 minutes. Judges, do you have any questions?
I do. So, Mr. Locke, going to the argument that you're on right now, no explicit instructions to bring this stuff, but she was instructed you're going to be working back in the office now that the COVID work limitations are being relaxed a little bit. And she did take all of the employer's equipment home with her. That was the only way she was going to be able to do the job at home in those intervening, many months, correct?
Yes.
Okay, so isn't that implicit that you have to bring this stuff back?
Not necessarily. There isn't an indication that it was absolutely necessary for her to bring any specific materials or equipment back to the office in order to do her job.
Well, and how, doesn't she use that equipment to do her job? I mean, that's where I'm kind of stuck with.
Well, what she did is she used the equipment to work at home during COVID, yes. And when the day came that she was going back to work, she took some of that equipment back to the office for that first day, yes.
Okay. And that's kind of my point. Isn't that you're going to come back and work now at the office, hybrid. Isn't it implicit that she has to bring this stuff back? That's where
From the standpoint, it certainly could be construed by her, and she indicated that she needed to be there at 8 o'clock to start her workday. So it could be implicit, yes, that she needed to bring that information back. I do agree with that. However, there wasn't anything on the record that indicated that she was instructed or told or directed in any way to do that on the record.
Okay.
But didn't she testify that she was instructed to do so? So that would be part of the record?
No, at no point did she testify that she was instructed to do that at all. Her exact testimony was work times. When she was asked if she was supposed to return at a specific time, she testified work times were 8 to 4:30, and it was required to me. And she's saying required to me. She isn't saying that she was told by anyone. It was required to me to be at work before 8 o'clock so I could set things up. She didn't indicate what things she was going to set up or that anyone specifically told her anything. There wasn't an indication on the record of there being a directive or an order from the employer that she was supposed to do anything specific other than you need to be back to work according to the new order as of Wednesday, September 8th, 2021, and work starts at 8 o'clock like it has for the last 20 years.
And then what about this hybrid schedule then? I mean, the injury happened right away, but was the idea that she was going to be transporting equipment back and forth, some days working at home, some days working at work?
Well, what she did do, and that's what we do know, is what she did do. And she took that in the materials that she had. She took a laptop, some cords, a microphone, I believe she said. There would have been a few other things. She took those to work on Wednesday mornings, and she brought them home on Friday afternoons. That is what she did do, yes.
Okay. So that goes to this is just routine run-of-the-mill commute to work.
Well, not only does it go to the routine run-of-the-mill return to work, it also goes to the reoccurring aspect of this also. This was a constant and continuous thing that was going to happen every Wednesday morning and every Friday afternoon.
All right, so the operative word for me there is going to happen. So up to that point, it didn't happen. This is the first time that she was to bring her equipment, the employer-owned equipment, back to work. So there was no established routine at that point, correct?
There wasn't an indication on the record, Judge, that there was an established routine at the point in time on September 8th of 2021.
Thank you.
And just so I'm clear, because I have it in my mind, September 8th of 2021, that was the first day she was going to start this. You got to come back to work thing. And that's when the new hybrid schedule was going to begin. Or I guess would have started on Tuesday because Labor Day was the Monday. So, but this was the first day that she was going to go back to work. So it would have been the first day of a reoccurring schedule, if I understand correctly.
That's the way I see it, yes.
What about, I asked Mr. Schwab this, what about this finding by the compensation judge that she did not find the employee's explanation of how the work injury happened on September 8th to be credible or to be reliable? Mr. Schwab responded, doesn't matter how it happened. All it matters is it did happen. Does it matter on a special errand analysis?
Well, here, Judge, there was not a special errand. It did not occur. There's nothing to indicate that there was a special errand here. And so in that sense, I do believe that it would be necessary that there would be a cause of the injury that arose out of the employment. And that is not the case here.
But assuming it is a special errand case, How would you respond to that?
Could you repeat how
Yeah,
you're
so,
asking it, Judge?
so assuming that this is a special errand case, is there a necessary element that the act of loading the vehicle caused the fall? Do you need to show some correlation or connection between an act and the fall
I
and
do
the
think
injury?
that you would. Yes, Judge.
Okay, thank you. Was the act of putting that equipment into her van, the process of doing that task, was that in the employer's interest?
I don't believe it was in the employer's interest, no. I mean, it was her regular commute. And so in the sense of what she was doing, it was all part of, and necessary for the commute in getting herself to work and being ready to work at 8 o'clock in the morning.
Any other questions? Go ahead.
Okay. Let's see, we got to the integral part on the trip. We got to the regular and reoccurring. Let's move on to the special hazard, as far as the special hazard is concerned. With respect to that, we know the case law, and the case law indicates that there needs to be an exposure, that the employee being exposed to a hazard originating on the employment premises. That's number one. Or number two, that the employee was exposed to a different or greater hazard than when she was attending to personal affairs. What we don't have here is a situation where the employee there wasn't something that arose out of the employment or anything that was a different or greater hazard than she would have been doing her personal affairs. In her brief, the appellant lists unsubstantiated information as well as her own medical and legal hypotheses, which are not supported by the record and are, by her own admission, speculation. In fact, the appellant's conclusions are direct contradictions to her own testimony and require the assumption of facts not in evidence. For instance, the appellant's brief includes 3 statements, each without any citation to a finding of fact or to the record. 1. Ms. Ludwig fell on September 8, 2021 due to pushing the bin into her car. 2. Her required exposure to the additional weight caused her to fall. Or 3. Ms. Ludwig testified at hearing that she lost her balance while shoving the heavy plastic bin with work equipment into her car. None of these statements are supported by the record. However, at hearing, the appellant did testify that the time she fell on September 8, 2021, wasn't dizzy, she didn't feel off balance, there was nothing about the equipment she was moving that contributed to her fall, and that she did not have any idea what caused her to fall. Judge Surges, in finding number 9, found that she did not know if anything contributed to her fall, and she did not know if she still had her hands on the bin when she fell. The bin did not fall on top of her, and nothing fell out of the bin. Now, in her memorandum, Judge Surges noted similarities between the appellant's September 21 injury and the facts of the Thompson case. We know Thompson as far as commuting to work and carrying a briefcase of items from home, but admitted that the briefcase did not cause his fall or worsen the effects. In the appellant's case, the September 8 event did not occur on the employer's premises. Her fall occurred at her personal residence before her scheduled shift, while she was not working and while she was not being paid. The only alleged work connection is the bin of equipment. However, the bin, by appellant's own admission, did not cause or contribute to her fall. So as far as we're concerned, Judge Surges considered the special hazard exception also, found it inapplicable, and determined that the September 8, 2021 injury was not compensable. Next, appellant claims that the case is analogous to Olson, which it is not. Olson was not certain exactly which of a multiple of precipitating factors caused him to fall. There was a narrow outdoor walkway, poor lighting, frosty wet leaves on the ground, and the compensation judge found Olson credible. He determined that collectively these circumstances increased Olson's exposure to injury, and there was a causal connection. In this particular case, and you have noted, we are not dealing with a reliable witness. Finding 13, 25, and 27, Judge Surges found the appellant's testimony was unreliable. She stated that the compensation judge does not find the history provided by the employee as to how the September 8, 2021 injury occurred reliable, as it has changed many times over time. Here, the present case does not involve multiple contributing factors like in Olson. Rather, it involves a lack of factors. At hearing and on appeal, appellants argues that the preponderance of the evidence standard should not apply to her. Instead, she argues that the court should have found her injury compensable through a process of elimination. Appellant's theory is that even though she explicitly testified to the contrary, the bin must have caused her fall because she did not know what else could have caused it. The process of elimination test does not exist in Minnesota workers' compensation law. Here, Judge Sturgis specifically analyzed the facts of the case under the special hazard exception and found that it was inapplicable. In conclusion, the Workers' Compensation Act required that the appellant to prove her case by a preponderance of the evidence, and again, not a process of elimination. Appellant failed to meet the burden of proof at trial level and has failed to show that Judge Sturgis' findings were clearly erroneous and unsupported by substantial evidence, or that Judge Sturgis committed an error of law, and we ask this court to affirm. Thank you.
Thank you, Mr. Locke. Judges, do you have any questions?
No additional question.
Thank you. Mr. Schwab, you have 1.5 minutes to rebut the argument of Mr. Locke.
Thank you. I have just a few notes to bring up. First, I think it's unfair to classify Ms. Ludwig as an unreliable witness. In certain portions of Judge Sturgis's decision, she notes that some of the testimony on the mechanism of injury is unreliable, but in other portions, she does describe the employee's ability to describe things such as her activities of daily living accurately and credible. So I think it's unfair to call Ms. Ludwig an uncredible witness, given that depending on the topic, the judge had different opinions on it. Second, the trip on September 8th, 2021 was not routine. Ms. Ludwig normally leaves at 7:30 in order to go into work and be in there by 8. She testified and the judge found in the record that she left at 7:15 that morning. The reason she did that is because she understood and acknowledged that she needed to set up her work equipment, that she was being asked to do an additional task. And on the conference call with her supervisors, I think that was clear. This was not something reoccurring. She was not bringing her work chair and multiple monitors in on a day-to-day basis, and the record shows that as well. Ms. Ludwig was on a special errand on September 8th, 2021. Her fall should be compensable. We ask that this court reverse that determination and then remand back for additional findings. Thank you.
Questions? I have one question.
Sure.
I'd like you to respond to what Mr. Locke said in his argument about the first element of the special errand exception, which is, was there a request, implicit or explicit request, that a service be performed outside of her working hours? Was there?
Yes, there was.
Tell us about that.
Yeah, so Ms. Ludwig on a conference call with her supervisors was instructed to return to work and set up her work equipment and be ready to begin her normal job activities at 8 a.m. Logically, the only way to do that would be to set up her work equipment prior to 8 a.m. Not only does Ms. Ludwig testify about that conversation, but her conduct shows that as well. The fact that she's leaving earlier for work than her normal scheduled time shows that her understanding of that call, whether explicit or implicit, caused her to actually leave earlier for work than she normally would. So both the unrebutted testimony and her conduct show that she was asked to perform this special errand.
Thank you. All right, the record is now closed. This decision will be issued within 90 days. Before we adjourn, I just wanted to compliment both of you on a very well presented argument. You have given us a great deal to consider today, well prepared, and we appreciate it. So thank you. We are now adjourned.
Six when you prepare all. Or do I need to just?
Isn't that how it always goes?
And then, yep. And